Hello and welcome to BYJU'S Exam Prep. Welcome to Target Mains 2022, a must-attend crash course cum revision program for Mains 22 aspirants. What are the highlights of this program? Number one, we will be discussing 130 plus current affairs topics live. Number two, we will be discussing the answers related to 130 plus topics concerning the static part of your main syllabus. Special lectures on essay writing, special lecture on GS paper 4 ethics case studies. Every week, we shall give you a set of questions. Write answers to these questions, submit to us, and we shall evaluate and share our feedback. If you submit your answers between 10 o'clock in the morning and 6 o'clock in the evening, we shall evaluate these answers and provide our feedback within an hour of your submission. If you submit later than 6 p.m., we will share our feedback but the next day. All these lectures shall be exclusively available for free and on BYJU'S Exam Prep app. The first two lectures will be available on our YouTube channel, but the remaining lectures, remaining part of the crash course, will be exclusively available on the BYJU'S Exam Prep app. The link to download the app is provided in the video description as well as a pinned comment. But first up, why is it that this crash course is exclusively available on the BYJU'S Exam Prep app? There are two reasons for that. Reason number one, if you attend these lectures on the app, you will get to interact with the faculty, you will get to ask your doubts, questions, and you will get the instant resolution of your doubts by the teachers. That's reason number one. Reason number two, app is distraction free. For example, if you're attending these lectures, if you're consuming content on YouTube and you're also scrolling through the YouTube content, it may be possible that you will try and watch the trailer of a movie or you will watch a song. Basically, YouTube is a distraction. Mains is a serious examination. The marks that you score in mains plus the personality test shall be added, and that will determine whether you are qualifying this examination or not and what is going to be your rank as well. Mains is even more important because of the sheer amount of marks that are allocated to mains, 1750 marks. So since it is a serious examination, we want you to have a distraction-free environment of learning. That is why these lectures shall be exclusively available on the BYJU'S Exam Prep app. So let's get started. Today and tomorrow, we will look at some of the polity-related current affairs topics and analyze them from the mains perspective. Which are these topics that we are going to cover today and tomorrow? Number one, capital punishment or death penalty. Second, Shatrughan Singh Chauhan case of 2014. Third, Medical Termination of Pregnancy Amendment Act 2021. We will look at the essential religious practices doctrine. We will be looking at the dowry deaths in news over a period of time, the Tribunals Reforms Act of 2021, and the role of governor. Role of governor, which is in the news even today. Something has happened in West Bengal where the governor has been removed as the chancellor of the state universities. But look at me carefully. These topics we are going to analyze from the mains perspective. That means the standard of these lectures is going to be slightly higher than whatever you have been witnessing over the past many years, because this is our first program specifically targeting the mains 2022 aspirants. So the standard is going to be slightly higher, but if you're liking these initiatives, whether it is the knowledge series that we do every day live 10 o'clock and 3 o'clock in the afternoon, or our daily newspaper analysis or the daily quiz or the explained videos, economy this week, and now this target mains crash course or the target prelims crash course that we did just before the prelims examination, which you are basically saying has been of immense help. Some of the students have been in a position to score 140 plus, and we are thanking the target prelims initiative that we did. But if you're liking these initiatives, press the like button, comment once the stream is over, subscribe to our channel if you haven't yet, and share the links of these classes with your friends and fellow aspirants. Let's get started and look at topic number 1, capital punishment. But what is the context? 38 individuals were sentenced to death this year because of their involvement in 2008 Ahmedabad serial blasts. Now, there are 3 arguments on this capital punishment, the idea of capital punishment or death penalty. There are some who advocate that capital punishment should continue. There are some who advocate that capital punishment should be abolished. And there is a third argument as well, which becomes important for your mains examination. The third argument is that there should be a temporary moratorium on the capital punishment till we have a clarity. What sort of clarity are we looking at? That is something that we are going to discuss today. So first up, let's look at the arguments in favor of capital punishment. What sort of question can be asked? The capital punishments, the look of capital punishment on the statute books, it is very important to ensure deterrence of crimes. That means the idea to retain capital punishment on statute books will deter future commission of crimes, justify. So we'll have to justify the idea of capital punishment on our statute books. Argument number 1 is, why we should have capital punishment on the statute books, and that argument is retribution. Now, what is this retribution? Number 1, all guilty must be punished. Number 2, only the guilty shall be punished. And number 3, all guilty should be punished in accordance with the severity of their crimes. Higher the severity of crime, higher should be the punishment accorded to these individuals. That is retribution. And if you look at this retribution, the idea is that whoever has committed crime, for example, murder, highest offenses against the state, their life deserves to be extinguished. That means argument number 1 in favor of continuing with the idea of capital punishment is retribution. Number 2, deterrence. What is this idea of deterrence? Let's say, for example, here is a live wire. You and me, we are watching this live wire. I touch this live wire. What will happen? Shock, electric shock to me. Now, seeing me that I witnessed an electric shock because I touched the live wire, will you touch this live wire? No. Which basically means it will act as a deterrent. Those individuals who commit crimes, violence against women, crimes against the state, murder, dacoity, if they are also, their life is extinguished, it will deter others from committing this crime. So argument number 1 in favor of capital punishment is retribution. Argument number 2 is deterrence. Argument number 3 is rehabilitation. And this argument of rehabilitation, we say that this is favoring the convict. That means from an convict's perspective, rehabilitation is one ground on the basis of which we say that capital punishment should continue. Now, what is this rehabilitation? Of course, capital punishment cannot rehabilitate an individual. He is too dead to be rehabilitated because his life has been extinguished. But what will happen is that when this person is about to be hanged, he will try and make peace with his God. He will act remorseful. He will seek repentance from all the crimes that he has committed. And ultimately, he will ensure and experience some sort of spiritual rehabilitation. That's what Italian philosopher, Italian priest, Thomas Aquinas has noted. What he has noted is that by accepting the punishment of death, the offender was able to expiate evil deeds so that he escapes the punishment in his later life, in his afterlife. So one more argument in favor of retaining capital punishment on statute books is that of rehabilitation. And we say this argument favors the accused, favors the convict, favors the offender. Argument number 4, prevention of reoffending. If I am a murderer, I have committed murder, and now the court says you are guilty, you hang by your neck till death, which means my life has been extinguished. One thing that it is going to ensure It will prevent reoffending. That means I will no longer commit another murder because I'm too dead to commit another murder. So one argument in favor of retaining capital punishment is retribution. Second, deterrence. Third, rehabilitation, which is some sort of a spiritual rehabilitation. Fourth, it prevents reoffending. That means it prevents reoffending of these crimes because this person who has committed this crime, now he is no longer able to commit another crime because his life has been extinguished. Fifth argument, it gives a sense of closure to the victim's family. I was killed by an individual. Now what happens when this individual is also killed, when his life has been extinguished, when he has been hanged, it will give some sort of closure to my family. They will now make peace with God and will give them a sense of vindication that this individual who took the life of our son or our friend or our brother or of our husband, this person has now been hanged. So fifth argument in favor of continuing with capital punishment is that it gives sense of closure and sense of vindication to the victim's family. And fifth is a Japanese argument. And what is this Japanese argument? In Japan, they do not use capital punishment quite frequently. In fact, Japan hangs less than 3 individuals every year. But the public opinion in Japan favors capital punishment. Why? Because there is a Japanese argument which says good things happen to those who do good, bad things happen to those who do the bad things. That means if there is an individual who has been hanged, why? Because he committed murder. The public opinion feels that this person was hanged because he did a bad deed, an evil deed. That means bad things happen to those who do bad things, evil things, and good things happen to those who do the good things. From the ethical perspective, this is a consequentialist argument. And now what is a consequentialist argument? What is the consequence of an act? The act is we are hanging an individual. If the consequence of this hanging leads to maximum happiness for the maximum number of people, then this act is a good act. That means by hanging this person who has committed some wrong, its consequences that it leads to larger public opinion also believing, also feeling that good things happen to those who do the good things and bad things happen to those who do evil deeds. So capital punishment, one school of thought, they say capital punishment should not be abolished, it should continue. And there are 6 reasons for its continuation which you can write in your answers. Number 1, it acts as a deterrent. Number 2, it prevents reoffending. Number 3, it gives us some sort of rehabilitation. Number 4, it gives him some sort of closure to the victim's family. Then there is a Japanese argument. And the last important argument is retribution. But then there is another school of thought which believes that capital punishment should be abolished. Now, if you were asked to write on the arguments against capital punishment, how should you start? Let me give you one paragraph, you can note it down as well. Advocating for the abolition of capital punishment when there is a surge in the incidence of crime against women may appear morally dubious. What rights do people guilty of such heinous a crime lay claim to? And what do they deserve but death, you might be inclined to ask. But when you apply an immoral law to monstrous criminals, it becomes comparably easier to make iniquitous laws, unfair laws, unreasonable laws for the rest of us. Capital punishment goes against the idea of criminal justice system, and its application in the rarest of rare case speaks to a larger incoherence in India's penology. I'll repeat. Advocating for the abolition of capital punishment when there is an increase, when there is a surge in the incidence of crimes against women, against marginalized sections of the society may appear morally dubious. But what rights do people guilty of such heinous a crime lay claim to? And what do they deserve except death, you might be inclined to ask. But when you apply an immoral law to monstrous criminals, it becomes easier to make comparably iniquitous laws for the rest of us. Capital punishment goes against the core idea of criminal justice system, and at the same time, its application in the rarest of the rare case, as mandated by the Supreme Court, speaks to a larger incoherence in India's penology. Now let me explain. Today's debate on the abolition of capital punishment can be traced way back to 1764, when an Italian jurist, Cesare Beccaria, published his treatise. And this treatise was known as An Essay on Crimes and Punishment. In this, Beccaria argued that abolishing capital punishment is critical, is crucial, if a society has to transition from barbarity to civilized refinement. Beccaria argues that abolition of capital punishment is crucial for the transition of a society from barbarity to civilized refinement. Beccaria asked a very important question. He says, is it not absurd that laws which should detect and punish murder should, in order to prevent murder, publicly commit murder itself? We have laws and we pass these laws so that we can prevent murder. And the same law says, if you commit murder, we will kill you. That means this is some sort of what is mentioned in Old Testament, eye for an eye, retribution. Beccaria argues, is it not absurd that laws which should detect and prevent homicide, murder, should, in order to prevent murder, publicly commit murder itself? Beccaria's argument is based on two important things. He says the objective of punishment is dual. There are two objectives why we should punish an individual. Number one, we should punish an individual so that we can deter future commission of crimes. And the reason number two, why we should punish people, is that we should reform the offender. Now, does capital punishment act as a deterrent? Let's look at the data. If you look at United States of America, there are some states which have abolished capital punishment, and there are some states which have retained capital punishment as a punishment for some crimes. If you look at those states where capital punishment has been abolished, the murder rates are less. And if you look at those states where capital punishment stays as punishment for some crimes, the rates of murder and homicide are higher than abolitionist states. So clearly we can say that capital punishment does not act as a deterrent. It does not deter future commission of crimes. If I'm a terrorist, what am I scared of? I'm not scared of death because I'm also a suicide bomber. I use a vest which is laced with ammunition, with bombs, and I want to blow myself up and I want to kill my enemy. So I'm not scared of death. What am I scared of? I'm scared of imprisonment. So capital punishment does not act as a deterrent. And capital punishment cannot reform an offender because this person is too dead to be reformed. He has already been killed. He has already been hanged. His life has already been extinguished. So given that capital punishment does not act as a deterrent, or best we can say that the reason or data or justification that capital punishment does act as a deterrent, this argument is very weak. So given capital punishment does not act as a deterrent, plus it cannot reform an offender. So why do we need capital punishment? Because both the objectives of punishment have not been followed. And Beccaria also says that it goes against social contract. If you are a student of political science, you would have read about theories related to social contract, that there is a contract between the state and citizens. And if the state has the power to take the life of a citizen, this violates the social contract. So Beccaria says that the objective of punishment are dual. One, to deter future commission of crimes. Number 2, to reform an offender. Since capital punishment does not act as a deterrent, since it does not reform an offender who is too dead to be reformed, then why do we have capital punishment on our statute books? Because it also violates the contract, the social contract between the state and citizens. But now let's look at Lord Macaulay, another argument. Lord Macaulay, he was the drafter, the author of Indian Penal Code when it was drafted in the year 1860. Lord Macaulay writes in the introduction to Indian Penal Code that there were many who came to us that gang robbery, it's a very important statement, gang robbery and rape, these are also heinous crimes, and these also should be punished with murder. If somebody commits murder, according to Indian Penal Code, we hang that individual, we kill that individual. Macaulay writes that there were some who said, why should we kill only those individuals who have committed murder? Why don't we also impose capital punishment on those who commit gang robbery, who commit rape? Macaulay says this is something that we should not do. Why? Because somebody committing gang robbery, somebody committing rape, and look at the beautiful argument. Somebody who commits gang robbery, somebody who commits rape, he always have the incentive to add murder to his guilt. Macaulay says, if we punish murder with death, and if we punish gang robbery and rape also with death, then there is no incentive for this criminal to spare the lives of those whom he have injured. For example, I am committing rape or I am committing gang robbery. I know that if I commit rape, I will be sentenced to jail. But if I commit murder, I will be sentenced to death. Macaulay says that when somebody is committing rape, he always has the power to add murder to his guilt. And if the punishment for rape as well as murder is the same, then if I rape a woman, I will also kill her because the punishment is the same. But if the punishment is different, for rape it is jail, for murder it is death, I will spare the life of a woman I have raped. So clearly, Lord Macaulay is explicit, saying that the argument why we have capital punishment under Indian Penal Code is that capital punishment acts as a deterrent. But we are in 2022, more than 2 centuries later. Even then, we have not been in a position to exclusively prove that capital punishment acts as a deterrent. So why have capital punishment on the statute books? Then came something else. Bachchan Singh versus State of Punjab 1982 case. In this case, you would have read about this case. In this case, the Supreme Court said death penalty should not be awarded in any and in every case, but it should be awarded only in the rarest of the rare cases. But which are these rarest of the rare cases? It has all the ingredients of a roulette table. For example, I am a judge. I hear a particular case. I would say this is the rarest of the rare case, give him death sentence. But here is another judge who says, no, this is not the rarest of the rare case, give him life imprisonment. That means even this rarest of the rare doctrine gives an element of subjectivity to a judge. A particular judge may not say that this is the rarest of the rare case, while the other judge may look at the same case and say this is the rarest of the rare case. So even the invention of this doctrine of rarest and rare by the Supreme Court in Bachchan Singh case, it has all the ingredients of a roulette table. And that's what former Chief Justice of India, Justice P. N. Bhagwati said. He asked a very critical question. He said, am I to live or die depending upon the way benches are constituted from time to time? One bench may say this is rarest of rare. Another bench will say this is not the rarest of rare. So if I am an accused, I will have to pray that I should come before a bench which should say that this is not the rarest of the rare case. So am I to live or die depending upon how benches are constituted from time to time? Is it not violative of the fundamental guarantees provided under Article 14 and 21 of the Constitution? So one argument against capital punishment is, number one, Cesar Baccaria's argument. The objective of punishment should be two. One, to act as a deterrent, and number two, to reform an offender. We have no data to suggest that capital punishment acts as a deterrent. Clearly, capital punishment does not reform an offender, and it also violates the social contract between the state and the citizens. Lord Macaulay was clear while writing an introduction to Indian Penal Code that we are keeping capital punishment as a punishment for some crimes because capital punishment acts as a deterrent, but it clearly does not. And at the same time, even this invention of doctrine of rarest of rare, it has all the ingredients of roulette table. Justice P. N. Bhagwati's quote you can use in your answers. Am I to live or die depending upon how benches are constituted from time to time? Is it not violative of the fundamental guarantees enshrined under the Constitution under Article 14 and 21? But the biggest argument against the idea of capital punishment is that it is irrevocable. It cannot be revoked. I was arrested and I was told by the judiciary that you are guilty and you are sentenced to life imprisonment. Few years later, new evidence came up. New evidence which says, no, I am innocent, I am not guilty. Now what will the court do? The court will set me free. But what if I was already hanged? Can my life be given back to me? Now you might say this won't happen in the real life, this might happen in a Bollywood movie. But it has happened. Supreme Court in Santosh Kumar Baryar versus State of Maharashtra 2009. The Supreme Court said that 13 death sentences which have been awarded by the judiciary, they are rendered per incurium. Or should we say they are rendered in ignorance of the law. That means the law which was laid down by the Supreme Court in Bachchan Singh case, in 13 instances this law was badly interpreted, wrongly interpreted, and that is how capital punishment was given to 13 individuals. And what makes it even more worse is that 2 out of these 13 individuals were already hanged. You can write another important phrase, another important line, paragraph in your answer. In a country where an accused's right to free legal aid is at best a mockery, retaining capital punishment sounds a virtual death knell to the Constitution. We all have free legal aid. If we cannot afford a lawyer, a free legal aid is provided to us, which some people say is a mockery. In a country where an accused right to free legal aid is at best a mockery, retaining capital punishment sounds a virtual death knell to the Constitution. Retaining capital punishment goes against the core objectives of criminal justice system. Justify can be asked in your mains examination. And how it goes against the core objectives of criminal justice system? Number one, the objective of a crime, of a punishment should be it should deter future commission of crimes. And at the same time, it should reform an offender. Death penalty neither acts as a deterrent nor reforms an offender. Until the time we have a clarity on Bachchan Singh case, till the time we have a clear-cut guideline as to what constitutes rarest of the rare, so that we don't leave it to the subjective bias of the judges, till that time there should be a temporary moratorium, temporary stay on the capital punishment in India. These are the 3 arguments. So capital punishment as idea number 1, argument in favor of capital punishment, and we have listed down 6 arguments. Number 2, capital punishment should not continue. Why? Because of these reasons which we have discussed. And the third argument, which can be your conclusion, till the time there is a clarity on what constitutes rarest of the rare doctrine, so that there is no subjective bias on part of the judges. There should be a temporary moratorium on the imposition of capital punishment in India. Full stop. Topic number 1, capital punishment, is over. Okay. Now let's look at another important judgment. Shatrughan Singh Chauhan versus Union of India 2014. What is the context? Two sisters on death row spared the news by the Bombay High Court, and in this judgment the court cited Shatrughan Singh Chauhan 2014 judgment. And at the same time, if you look at the Perarivalan case, the Rajiv Gandhi assassination case, in which one accused was Perarivalan, who has now been released on the orders of the Supreme Court, there also the Supreme Court quoted Shatrughan Singh Chauhan judgment. Now you might ask, sir, this is the judgment of 2014. How can it be asked in 2022? There are numerous examples where old judgments have been asked in your exam. For example, 2007 IR Kolo judgment. It was asked by the Supreme Court. It was asked by UPSC 10 years later. So if any judgment is in the news, it becomes a potential topic context for your mains examination. What can be the question? The Shatrughan Singh Chauhan judgment of 2014 has humanized capital punishment discourse in India. Justify. So what is the Shatrughan Singh Chauhan judgment? Few points we will mention, more than enough for 150 to 200 words, and we will be done with this topic. Number 1, what did the court say in this judgment? Because it has humanized the idea of capital punishment in India. The court said, and look at me carefully, the court said, when the judicial process is complete, that means when the court has said that you are guilty, you hang by your neck till your death. Judicial process is complete. After that, what happens? The convict files a mercy petition before the President of India or the governor of a state. This process must be expeditiously completed. Why? Because what we follow in India is a due process of law. And due process of law says all the procedures must be fair, reasonable as well. And what is the procedure? An accused, a guilty, is approaching the president, filing a mercy petition. This mercy petition should be expeditiously decided whether the president accepts this mercy petition or rejects this. If you do not follow this procedure fairly, transparently, then this amounts to torture. And torture is clearly violative of Article 21 of the Constitution. So one important argument which was presented by the Supreme Court in Shatrughan Chauhan judgment was, number 1, whenever the judicial process is complete, the mercy petition should be disposed of by the president or the governor expeditiously, because we follow due process of law. And if there is no expeditious disposal of mercy petition, then it amounts to torture, which is violative of Article 21 of the Constitution. How is it torture? I don't know whether I'm going to live tomorrow or not. Because I was sentenced to death by the Supreme Court, I filed a mercy petition. The president is not working on this mercy petition, is not deciding this mercy petition. So I don't know whether I'm going to see tomorrow or not. And this uncertainty in my life is a torture, and it is violative of Article 21. That's point number 1. Point number 2, what the court also said, the court said whenever there is an inordinate delay in disposing of these mercy petitions, then this inordinate delay shall lead to commutation of death sentence. There have been mercy petitions pending before the president for 11 years, for 20 years, for more than 3 years. Why is there an inordinate delay? Unexplained delay. What led to the delay in disposing of these mercy petitions? If there is an inordinate delay, the court will commute the death sentence to life imprisonment. The court did not fix the time as to how many years should have passed so that we can say that there is an inordinate delay. But the court said whenever there is an inordinate delay, it will lead to commutation of death sentence to life imprisonment. Third important point, what Shatrughan Chauhan judgment talked about, is that somebody who is suffering from mental illness, if there is a convict on death row who is now suffering from mental illness, for example schizophrenia, this person shall not be hanged, his death sentence should be commuted to life imprisonment. That's what people say. It has humanized capital punishments idea in India. At the same time, what the Supreme Court said is that 14 days should be given to this convict after the mercy petition has been rejected. So 14 days should be given to this individual so that he can settle his worldly affairs, so that he can transfer his property to somebody, so that he can meet up with his family, so that he can make peace with his God and ultimately accept the reality of death. After the rejection of mercy petition, give 14 days to this convict to settle his worldly affairs and then hang this individual. And give opportunity to his family to meet this convict. That is how the court, what it has done, it has humanized capital punishment in India. These are the 4-5 important points. But then there is a critical side to this as well. Critical side to Shatrughan Singh Chauhan judgment, which we have to also write in the examination. And what is that critical side? According to the rules, one critical argument against this judgment is that this is convict centric. This judgment is not victim centric, this is convict centric. Number two, rules say if, for example, Nirbhaya was gang raped, there are 4 accused in this case. The rule says all these individuals who are accused in this case should be together hanged, in one day hanged together. Now accused 1 is filing a mercy petition. It is rejected. Now ideally this person should be hanged, but no. Now the second person says, I will file a mercy petition. His mercy petition is rejected. Now comes the third person. He is filing a mercy petition. So what they are doing, they are ganging up together to delay the execution of death sentence, death penalty. One reform that we can suggest to make this judgment victim centric is that if one person's who is accused in this case, convict in this case, if there are 4 individuals, one individual's mercy petition is being rejected, let this person be hanged so that the others, if their mercy petition is pending, it has no bearing on the rejection of the mercy petition of criminal 1, convict 1. That is how we can reform this judgment so that it now becomes victim centric as well, because right now it is convict centric. This completes our discussion on topic 2 as well. So topic 1, we discuss capital punishment, the arguments in favor, arguments against, and there should be a temporary moratorium on capital punishment till we have a clarity as to what exactly constitutes rarest of the rare case. Case number 2, topic number 2, Shatrughan Singh Chauhan judgment of 2014, which has humanized capital punishment in India. But we also looked at it critically, saying that this is too convict-centric judgment. We have to make it victim-centric as well. That is topic number 2. Now let's look at topic number 3, abortion law in India. What is the context? India's amended abortion law still gives doctors, not women, the final say in terminating pregnancy. And why this topic becomes even more important is something is happening in United States. Roe versus Wade judgment of 1973. A landmark judgment of the US Supreme Court in 1973 known as Roe versus Wade. And it was in this judgment that the Supreme Court of United States said that the right of a pregnant woman to abort her child is also part of her privacy. And the Supreme Court invented something called trimester system. First 3 months, then 3 months, then 3 months. This 3-trimester system was introduced by the Supreme Court, allowing when abortion can be allowed. So it was considered to be a landmark judgment of the US Supreme Court, which put women's rights at a higher pedestal. But now there is a talk, there is a controversy, there are various reports which say that maybe the Supreme Court of United States is going to overturn this judgment. Is going to overturn this judgment, and we will go back to a place, to a time where women does not have the right to abort her child. That is why this topic becomes very important, not only because we have amended the Medical Termination of Pregnancy Act in 2021, but also because there is a raging controversy in the United States surrounding the potential overturn of Roe versus Wade judgment. Let's look at this topic in great detail from the mains perspective. One, we will look at what are the features of this law which was amended in the year 2021. What are the arguments in favor of this law? What are the arguments against this law? And what are the possible challenges and issues facing the abortion law in India? If you look at Indian Penal Code of 1860, it criminalizes the voluntary termination of pregnancy. Till the year 1971, there was no law on abortion in India. It was in the year 1971 when Medical Termination of Pregnancy Act was passed by the Parliament. According to this law, pregnancy up to 12 weeks can be terminated, but you need the consent of one doctor. Pregnancy between 12 to 20 weeks can be terminated, but you need the consent of 2 doctors or 2 medical professionals, medical practitioners. But this is not the right of a woman. It's not that up to 12 weeks I can go and abort the child. Between 12 to 20 weeks I can go and abort the child. No. Pregnancy can be terminated only if there is a danger. Danger to whom? Danger to the physical health or the mental health of a woman, of the pregnant lady. And pregnancy can be terminated if there is a danger to the fetus as well. If the fetus is suffering from some abnormalities. That means pregnancy between 12 to 20 weeks can be terminated if it affects the physical or mental health of a woman, or if there are abnormalities in the fetus and you have to approach one medical practitioner. If he says yes, there is a danger to your life or the life of your fetus, we will terminate the pregnancy. Medical termination of pregnancy. But if the pregnancy is between 12 to 20 weeks, then you have to seek the consent of 2 doctors so that these 2 medical practitioners can say that there is a danger, physical danger to the physical health or the mental health of a woman, or the fetus is suffering from some abnormalities. This was the law. But now we witnessed the why part of it. You have to ask, why was this law passed? Because this Medical Termination of Pregnancy Act of 1971, it was amended. And it was amended in the year 2021. And the first question that we need to ask is why? Why was it amended? What was the need to amend this law? If you look at this law, the statement of objects and reasons mentioned in this bill, when this bill was introduced in the Parliament, it says that more often than not, writ petitions have been filed in the courts. That means even after 20 weeks, if the pregnancy is because of rape, now this rape victim approaches the court after 20 weeks, because till 20 weeks you can abort your child. But after 20 weeks there is no provision in the law. That means the only recourse is now file a writ petition in the court, in the High Court or in the Supreme Court. That means the statement of objects and reasons of this bill said there have been numerous large number of writ petitions filed in the courts which call for abortion even after 20 weeks. That is why there is a need to change this law, amend this law, reform this law. And also science has made a lot of advancements. Now even after 20 weeks, the medical science has advanced to such a level that we can accurately predict whether this fetus is going to suffer from some abnormalities. And even after 20 weeks, we can abort the child. And now this amended law, what are the features of this law? The amended law says, now up to 20 weeks, you need the consent of one doctor and pregnancy can be terminated. But 20 to 24 weeks, and here there's a very important phrase that you have to keep in mind, certain categories of women whose pregnancy is in the range of 20 to 24 weeks, they can approach two doctors, two medical practitioners, and abortion can be prescribed, permitted, allowed. But what about after 24 weeks? Can abortion be allowed? Yes. But for that, the state has to set up a medical board so that this medical board can certify whether the fetus is suffering from some abnormalities. And if the fetus is suffering from some abnormalities, then we can prescribe termination of pregnancy. Abortion can be allowed. These are the features of this law. These are the features. Now let's look at the arguments in favor of this law, arguments against this law, and we will look at some issues as well from Mains perspective. Argument number one. There was a raging debate in US as well as in India whether you are pro-choice or pro-life. One segment of the society believes that abortion should not be allowed because this is the life which is given by God. Only God has the power to snatch this life. Abortion should not be allowed. These are pro-life individuals. Then there are those who are pro-choice, saying why? At any point in time, if the woman is not satisfied, she doesn't want the child, let her abort the child. So they are pro-choice. Argument number one in favor of this law is that the state has the duty to protect the life, which includes the duty to protect the life of a fetus as well. That is why we have to balance these rights. If the fetus is suffering from abnormalities, we can terminate the pregnancy. If there is a danger to the life, to the physical health, to the mental health of a woman, we can terminate the pregnancy. Otherwise, no. That means argument number one is that state has an obligation to protect the life, which includes the duty to protect the life of a fetus as well. That is why argument number one in favor of this law. Argument number two. Previously, the law said a married woman who is pregnant up to 12 weeks can terminate the pregnancy. A married woman who is pregnant between 12 to 20 weeks can terminate her pregnancy, and the reason should be medical reason. But now the liberal part of this law is, it talks about any woman. That means even unmarried woman has been included under this law. That is the other argument in favor of this law. Because an unmarried woman, she was in a relationship. There's a failure of contraceptive measures. Now she could not approach the doctors for termination of her pregnancy. And previously what she would do, she would go to a quack and get the pregnancy terminated. Now there is a medical alternative available to this unmarried woman. The law allows her to terminate her pregnancy because now unmarried women is also included. Even previously, those who were the rape survivors, they could also approach the court. They could also approach the doctors and terminate the pregnancy. Even now, if the pregnancy is because of rape, if the pregnancy is because of failure of contraceptive, then also this is a sound reason, legal reason to terminate your pregnancy. Third, we have increased the upper limit. Upper limit has been increased from 20 to 24 weeks. That's another argument in favor of this law. And from the polity perspective, we can say that even the state's duties or rights have been safeguarded. How? Health, my dear, is a state subject. Under the distribution of powers between the center and the state, health is a state subject. So how can Parliament frame such a law? The Parliament has safeguarded state's interest as well. Pregnancy between 20 to 24 weeks can be terminated based on the recommendation of the two doctors. But pregnancy after 24 weeks can be terminated if there is a abnormality in the fetus, and that the state medical board will decide, not the central board, state medical board will decide. These are the arguments in favor of this amended law of 2021. Now, what are the arguments against and what are the challenges? Challenge number one, choice of a pregnant woman. In India, it is still with the doctor's consent that you can terminate the pregnancy. What about the right of a woman to terminate her pregnancy? That right is not given to her. It is not an absolute right. There are 67 countries in the world where abortion is permitted based on the request by the woman, based on the decision of the woman. Despite the amendments in 2021, India is still not in the category of these 67 countries which gave unrestricted power to a woman to terminate her pregnancy. Termination of pregnancy is part of the reproductive rights of a woman. Why should there be a physical reason or a medical reason to terminate her pregnancy? Why can't we give this power to a woman that at any point in time she can decide that I don't want this child, I want to kill this child, I want to abort the child? This right is still not given. You may disagree with this argument, but nevertheless this is one argument, that choice of a pregnant woman is still not there. India is still not amongst the 67 countries which give unrestricted power, right to a woman to terminate her pregnancy. That's argument number one. Argument number two, I told you that if the pregnancy is between 20 to 24 weeks, then on the recommendation of two medical practitioners, abortion is permitted. But the law says certain categories of women who are pregnant in the range of 20 to 24 weeks. But who are these certain categories of women that Parliament has not mentioned, that the government will mention in their rules? That means this is some sort of a delegated legislation. Who are these certain categories of women who are pregnant in the range of 20 to 24 weeks, who have to approach two medical practitioners who can then allow abortion? Who are these certain categories of women? Ideally, it should have been recommended by the Parliament. It should have been mentioned by the Parliament. Who are these certain categories of women? But we have left it to the government, which means delegated legislation. We have delegated this power to the government, which ideally should have been prescribed by the Parliament. That's argument number two. That's issue number two, challenge number two when it comes to this law. Challenge number three, time frame. Let's say, for example, the law is silent. In the event of conflicting opinion given by two doctors, two medical practitioners, we have to approach two medical practitioners. Basis their recommendation, pregnancy can be terminated. But what if one doctor agrees, other doctor does not agree? The law is silent. The law is silent in the event of conflicting opinion given by the two doctors. That is another argument against this law. Fourth one, time frame for medical boards. even after 24 weeks, pregnancy can be terminated if there is some abnormality in the fetus. But this decision has to be taken by the medical board. In how many days, weeks, hours, years, decades, centuries, millennia does this medical board has to take a decision not mentioned in the law? Which means such a decision should be taken quickly. Which means we will still see most of the cases approaching the court. Why? Because when medical board will not give his decision on time, ultimately a rape victim, a rape survivor who is now pregnant, they have no other option but to approach and file a writ petition in the courts of this country. That's another argument against this law. Fourth, transgenders who have been subject to sex change surgeries. Are these transgenders also included in this law? There is no clarity, because it talks about woman, whether a married woman or an unmarried woman, transgenders, they do not fit in this criteria. So transgenders, whether they are included or not, is not mentioned. It's not clear in this law, despite the fact that in 2013 or 2014, the Supreme Court clearly said and recognized transgender as a third gender in this country. That's another problem. Fifth is, we say that two medical practitioners should give this decision, should take this decision, whether pregnancy should be aborted or not. But we have unavailability or the shortage of qualified doctors in this country. What is the data telling us? According to WHO, we should have one doctor per 1,000 population. But in India, we have one doctor per 1531 people. That means we are acutely short of practitioners, qualified doctors. Not just this. Let's look at all India rural health statistics of 2018-2019. In rural areas, in rural community health centers, we have only 1,351 doctors or gynecologists and obstetricians. There is a shortage of 4,002 doctors. That means 75% shortage of qualified gynecologists and obstetricians in rural areas, which means when the law says that this abortion should be prescribed by medical practitioners, qualified doctors, we have an acute shortage of these qualified doctors, which means people will still go to midwives, will still go to quacks and get the pregnancy terminated. That's another challenge. There is another challenge, and the challenge is, in India, 53% of abortions, they are done in private hospitals or private health clinics. Why? Because our public health infrastructure, our public hospitals, they do not have enough infrastructure to take care of these abortion related cases. 27% of abortions are done by women at home, which means there is another challenge to implement this law because we have an acute shortage of qualified doctors. Another challenge, POCSO and privacy. What is POCSO? Prevention of Children from Sexual Offences Act, according to which you have to keep the identity of the victim secret so as to ensure the privacy of this child victim. But this child victim who is this child victim who has been subjected to sexual assault and now she is also pregnant, she has to now approach the doctors for the termination of pregnancy, revealing her identity. Although the law says you should not disclose the identity of this child victim, but there will be victim shaming. And in a country where we are clothed with bias, it becomes very difficult for transgenders. It becomes difficult for child sex victims to approach the medical practitioners and doctors, because doctors sometimes they discourage them to approach them. So POCSO and privacy is another challenge in the implementation of this law. Another challenge, sex determination. If we have increased the duration from 20 to 24 weeks, which means more option, more time is available to their families. They will conduct sex determination tests illegally, although it is illegally, and ultimately we will see a skewed sex ratio at birth. Less number of girl children will be born in this country. Another important, medical practitioners' own morality. I'm a woman. I approach a medical practitioner that pregnancy should be terminated. I'm told, no, you cannot take this decision because the doctor is now imposing his own morality. You go and get your husband, or you go and get your parents, and then we will decide whether the pregnancy should be terminated or not. So this is going to be another challenge in the implementation of this law. So what have we discussed? Topic number 1, capital punishment. Topic number 2, Shatrughan Singh Chauhan versus Union of India. Topic number 3, Medical Termination of Pregnancy Act 2021. What are the provisions of this law? Arguments in favor of this law, arguments against this law, and some of the challenges that we will face and witness because of the shortage of medical staff, shortage of trained, qualified gynecologists and obstetricians, and that is some of the challenges vis-a-vis this law. This topic is over. Now let's look at the fourth topic that we will cover today, the Doctrine of Essentiality. After that, I will take some of the questions because we are live on BYJU'S exam prep as well. This live lecture is available simultaneously on our YouTube channel as well as the BYJU'S exam prep app. All the questions that are coming up on the app, I'm going to discuss these questions once topic 4 is over. What is the context of Doctrine of Essentiality? Hijab is not an essential practice of Islam, rules Karnataka High Court. Doctrine of Essentiality. Arguments in favor, arguments against, and we will briefly discuss that hijab case, what Karnataka High Court had to say when it banned hijab in government institutions. The year was 1954. A 7-judge bench of the Supreme Court in Shurur Mutt case invented this doctrine called Doctrine of Essentiality or Essential Religious Practices Doctrine. According to this doctrine, the court said that there is a religion. There are some integral features to a religion, essential features to a religion, and there are some non-essential features to a religion. Essential features of a religion will be protected, will be safeguarded. We will not touch these features. But if there are some features to a religion which are non-essential, and if they violate fundamental rights, these features will not be protected, these features will be turned down. That means courts in this country will now have a power to decide what is essential to a religion and what is not essential to a religion. One argument against this doctrine is that this doctrine has tended to lead the court into an area that is beyond its competence. The judges may be competent to decide on the questions of constitution, Indian Penal Code, Criminal Procedure Code, Comparative Constitution, but the judges are not competent to decide on the religious matters. That is argument number 1 against the doctrine of essentiality. Argument number 2, while applying this doctrine of essentiality, the courts in this country have been consistently inconsistent. How? Sometimes what the court has done, it has looked at religious texts to determine whether some features are essential or non-essential. the court. Sometimes when a matter has been brought before the court looks at the religious texts or the religious scriptures to decide whether this practice is essential to a religion or not essential. Sometimes it is looking at the empirical behavior of its followers. Sometimes the court is looking at whether this practice was in existence when the religion originated. What am I saying? Essential religious practices doctrine. Argument number 1 against this doctrine is that it has tended to lead the court into an area which is beyond its competence. Reason number 2, if you are saying that this is an essential religious practice doctrine, then you should be absolutely clear as to what is this doctrine all about, so that you can consistently apply this doctrine in all the cases which comes to you. But sometimes the court is looking at a religious text and a scripture to decide whether it is essential or non-essential. Sometimes it is looking at the empirical behavior of its followers to decide whether it is essential or non-essential. And sometimes it is looking at what? Whether this practice was in existence at the time religion originated. I'll give you examples. Example number 1. Temple entry case. Whether the Dalits should be allowed entry inside the temples or not. Those who challenged temple entry, they said, no, they should not be allowed because this is essential practice of our religion. The court looked at the religious scriptures and said, banning the entry of Dalits inside the temples, it is not an essential feature of your religion. That is why Dalits should be allowed entry. Another case, a particular sect, it said capturing and worshipping live cobra during Nag Panchami festival, it is an essential practice of our sect. The court said no. How? The court relied on a text. The text of Mr. P.V. Kane, the Dharm Shastras written by P.V. Kane to say no. Capturing and worshipping live cobra during Nag Panchami, it is not an essential religious practice of your religion. That means sometimes the court looks at the religious text or the religious scripture. Sometimes it looks at the empirical behavior of its followers. A Muslim personnel, a member of the armed forces, he was sporting a beard and now he was dismissed from the service. He approached the court and said, sporting a beard is part of my religion. Right to religion is a fundamental right. How can the armed forces in this country dismiss me from my service? The court said sporting a beard is not an essential religious practice of Islam. Why? The court reached this conclusion by looking at the empirical behavior of its followers. The court said if beard was an essential feature, why is Nasruddin Shah not sporting a beard? Why is APJ Abdul Kalam not sporting a beard? So sometimes it looks at religious scriptures, religious texts to decide whether a feature is essential or non-essential. Sometimes it looks at the behavior, empirical behavior of its followers. And sometimes it looks at this question as to whether this practice was in existence at the time the religion originated. For example, in the Ananda Margi case, the court had to decide whether Tandava dance is essential practice or not. The court said no, it is not an essential practice. Why? Because Anand Margi sect was founded in 1955 and Tandava dance was adopted in 1966. That means this faith, Anand Margi, it survived even without this practice of Tandava dance, which means when you can survive as a faith even without a practice, That means this practice is not an essential religious feature. That means argument number 2 against this doctrine is that in its application, the court has been consistently inconsistent in applying this doctrine. And this is something that the Supreme Court said. One judge of the Supreme Court said when the case was related to Sabarimala. In the Sabarimala case, 5 judges of the Supreme Court, a constitution bench of the Supreme Court, had to decide whether entry of women of menstruating age in the age group of 10 to 50, whether they should be allowed entry inside the sacred sanctum sanctorum of the Sabarimala temple. 4 judges of the Supreme Court said denying entry to women of menstruating age, it is not an essential religious practice. Hence, women of all age groups are allowed to enter the sacred sanctum sanctorum of the Sabarimala temple. Just one judge dissented, and her name was Justice Indu Malhotra. She criticized this essential religious practices doctrine. She said, religion is not a matter of logic. Religion is a matter of faith. What is essential to a religion, what is not essential to a religion, the court should stay away from it. Let the followers of that religion decide what is essential to that religion, what is not essential to a religion. We should not get into theological questions. That was Justice Indu Malhotra. And now this essential religious practices doctrine, very important point, is under review by the 9-judge bench of the Supreme Court. 9-judge bench of the Supreme Court is going to review the application, the continuance of this essentiality doctrine or essential religious practices test. But the point is, essential religious practices doctrine, what are the arguments against this? We have mentioned. You can cite the examples that I have given, even the argument of Justice Indu Malhotra. But there are others who say, what if essentiality doctrine is not there? Then how will the court decide these questions? Let's say there is a question on female genital mutilation. Female genital mutilation practiced by the Dawoodi Bohra community, which is a sect in Shia Islam. They have a belief that when a girl child attains the age of 6 or 8, her clitoris is cut. Why? Because the clitoris is an unwanted skin. It is the source of all sins, and this clitoris should either be completely removed or partially removed. There is a petition in the court which challenges the validity of female genital mutilation. Argument is, if there is no essentiality doctrine, then how will the court decide that female genital mutilation should not continue? The court can decide. And the court can decide by deciding this question on the grounds of health. The court can say female genital mutilation is unconstitutional without getting into this question whether female genital mutilation is essential practice of Dawoodi Bohra community or not, just by mentioning that it violates the health, it violates the dignity of a woman, and it is unconstitutional. Another important case which you can mention in your answer, Ismail Faruqi. In Ismail Faruqi case, the Supreme Court said the right to religion, right to practice religion, includes the right to allow an individual to have all those beliefs which deal with inward association of man with God. And this is part of an individual's autonomy. That means this right to practice your religion gives you the right to have all those beliefs which may be part of your inward association with your God. And this is your autonomy. And this autonomy has been recognized by the Supreme Court in at least 3 recent judgments. When the Aadhar judgment or the right to privacy judgment was given by the court in 2017, the court recognized autonomy. When Joseph Shine judgment was given by the court in 2018, which decriminalized adultery, the court mentioned autonomy. When Navtej Johar judgment was given by the court in 2018, it mentioned autonomy. So doctrine of essentiality is unconstitutional because it violates Ismail Faruqi judgment, wherein the court said that autonomy is very important and you can practice all your beliefs which are part of your inward association with God, which has been reiterated by the court in 3 recent judgments: privacy judgment, adultery judgment, section 377 judgment, which is known as the Navtej Johar judgment. But now let's look at why the Supreme Court said, why the Karnataka High Court said that hijab is not an essential religious practice of Islam. And this judgment may be asked in your exam, Resham versus State of Karnataka. The court said, number one, hijab is not an essential religious practice of Islam. The court again looked at religious text, scriptures, and came to a conclusion that since hijab is not an essential religious practice, banning of hijab inside the educational institutions, it is constitutional. The court said something else. The court said, although wearing a hijab is part of your freedom of speech and expression, may be part of your dignity as well, but freedom of speech and expression is not an absolute fundamental right. It comes under reasonable restrictions. And imposing a restriction on the wearing of hijab inside the educational institution, it is a reasonable restriction. The court said something else. 3, 4, and 5 points, very important points, can be asked in your exam. The court said dress is a derivative right. And when it's a derivative right, therefore it becomes weaker. That means wearing a dress is part of your freedom of speech and expression. Freedom of expression is a real right. But from freedom of expression, we derive another right, right to wear any dress of your choice. But it is derived from freedom of speech and expression, and as such is weaker right. Whether it's a sound argument or not, that is immaterial, but this is what the court has said. Fourth, what the court said school, it is a quasi public space. And in a quasi-public space, there can be reasonable restrictions imposed, where you cannot claim unfiltered, unfettered fundamental rights. And the fifth point, what the court said, is very, very important. The court said, uniform, which leads to homogeneous community, is strengthening secularism. These are the 5 arguments given by the court in Resham versus State of Karnataka. But there are some who criticize this judgment as well. Why do they criticize? They say number 1 criticism is, just 2 points I will mention and then we will end. Doctrine of proportionality and doctrine of reasonable accommodation. Doctrine of proportionality means that if state wants to achieve an objective, it must use the least restrictive method to obtain that objective. If you want to prescribe a uniform, but what is your objective? To have uniformity, homogeneity in your classrooms? For that, there should be a least restrictive way of imposing that uniformity. This is where the idea of doctrine of reasonable accommodation comes. And what is this reasonable accommodation? You prescribe uniform, and if the uniform is of blue color, accommodate hijab as well, but tell the girl students that this hijab color should also be blue. That means accommodate this diversity by prescribing that the color of your hijab should also be similar to your uniform, so that there is uniformity, so that there is homogeneity, so that it gives fillip to secularism, so that schools which are a quasi public space, there some element of homogeneity is ensured. These were the 4 or 5 topics that we discussed today. Why 5 topics? Because the first, we discussed capital punishment, arguments in favor, arguments against, and then your conclusion. Second, we discussed Shatrughan Chauhan judgment of 2014 because it was in the news. Third, we discussed Medical Termination of Pregnancy Act 2021. What are the provisions of this law? What are the arguments in favor? What are the arguments against? And then some of the issues. Fourth, then we discussed what is this doctrine of essentiality. And fifth, we discussed Resham versus State of Karnataka. Why the court said that hijab is not an essential feature of Islam, and what are the challenges or what are the critical arguments against this judgment. That brings us to the closure of this session. Now I'll take up all these questions one by one, which are there on BYJU'S Exam Prep app. Then we will end the session at 9 o'clock. We'll meet again tomorrow 7:30 in the evening, and we will discuss the remaining topics that we couldn't complete today. Questions, please. Sopan is asking, what is doctrine of proportionality? Let's say, what is the objective that the state wants to achieve? And there will be various ways of achieving that objective. You have to find the least restrictive method of obtaining that objective. For example, there is a mosquito, and the objective is to kill this mosquito. There are various options: AK-47, pistol, bomb, IED, BrahMos, nuclear missile, but there can be all out as well. Out of all these options, which is the least restrictive method to kill this mosquito? All out. Use this. Don't use other options. That is doctrine of proportionality. Any PDF of this topic? Yes, Ayush, the PDF will be uploaded on the Exam Prep app. Kritika, sir, can you kindly repeat the US case on abortion recently in the news? That is Roe versus Wade, which we discussed initially, where the Supreme Court of the United States said right to privacy, which is available to women, includes her right to decide on abortion. Aditi, sir, what is the current mandate of doctrine of essential religious practice? It continues, but as of now, it is also under review by a 9-judge bench of the Supreme Court. Would these videos be available here after the live stream? Yes, the videos will be available. Sir, what about answer writing? I am little confused. 2 days in a week, we will discuss answer writing. We'll discuss questions and how you should frame answers to these questions. And we will also give you an assignment, a set of questions which you have to answer. Send it across. We will evaluate. We will give you the feedback so that this ghost, this fear of answer writing, it also disappears. Don't worry. Empirical behavior of followers, the example that I gave you, that the court said prominent Muslim personalities, they don't sport a beard. That means it is not an essential practice of Islam. So what is the behavior of the followers? On that basis, the court decides whether it is essential or not essential. Sir, the concept of certain categories of women is decided by the government. That means the bureaucrats will decide. If the vote of thanks failed to get passed by Rajya Sabha, then the government has to resign. No, Nishant, the government will not resign because we follow parliamentary democracy where Council of Ministers are accountable to Lok Sabha, not to Rajya Sabha. So even if the vote of thanks is defeated in Rajya Sabha, that doesn't affect the stability of the government. Simran, this session will end at 9 o'clock. Sir, Siva is asking, sir, can we say judiciary is not always correct? Please keep one thing in mind. The Supreme Court is right because it is final. The Supreme Court is not final because it is right. The judiciary may not always be right, but there has to be the last word on a particular matter. And the last word is that of the judiciary. So judiciary is right because it is final. Judiciary is not final because it is right. Siva, I hope this is clear to you. Sir, what can be the conclusion for the doctrine of essentiality? Again, depends upon the question. What is the question asking? If the question is asking you to defend it, then the conclusion will be different. If the question is asking you to criticize it, then the conclusion will be different. The classes will continue till 1 week before the mains exam. The session will end. Sir, how to remember so many judgments? Is there any source for the same? BYJU'S exam prep. What if the Supreme Court gives unreasonable verdict? Can it be changed? You can challenge it. That's where the concept of review petition comes up, curative petition comes up, and Parliament also has the power to change, to pass a law, and which can override the judgment of the Supreme Court by changing the very basis on which the court based its judgment. That's something that Parliament has the power to do. Okay, that is it for today. Thank you for being with us. Have a great evening. Don't forget to like this video. Let us know in the comment section if it is of some benefit, of some help to you. See you again tomorrow, 7:30 in the evening. Till then, have a great time. Bye-bye. Good night.